things that we're asked to do as a panel is sort of give you our takeaways from today, sort of our highlights of what, if you don't remember, if you only remember a few things, what we sort of want you to remember. So I'll start, just because I've had more time to think about it than, than my other two panelists here. I think sort of picking up on a couple of themes that I felt like all of us sort of touched upon when trying to figure out the best way to give voice to a child in a proceeding is to be prepared. Be prepared for think about what the GAL may need, think about what the ARC attorney may need, think about whether or not you need these resources and these professionals pulled into your case, and how you would utilize them to help the child's voice be heard. The other thing that sort of jumped out at me is the notion, too, of really understanding your client, whether it's as ARC counsel or as representing a party, and stepping into a situation where knowing your client and knowing what their perspective is going to help you be more selective and more educated in your decisions about what information you bring to these other professionals. The third and final point that I sort of want to make is remembering the distinction that a GAL really is to make a decision, to make recommendations, I should say, based upon what they believe to be in the best interest of the child, and that they're not an advocate for the child. An ARC attorney, and if you are interested in doing the ARC training program, please get in contact with Jeff Melick, because I heard him say they definitely need more people that are certified to do that kind of work. But that the ARC attorney is really there to talk about what the child wants, and again, what the child wants may not be aligned with what you determine to be in his or her best interest. In which case, there are there's the rule that allows you to deviate from what your child's asking of you. But really, the point being that there are several different ways to bring a child's voice into a process, and to be aware of the resources around you. Your turn.
My turn. Okay. So, looking at this a little differently than what I usually say when I'm teaching the course, I'll look at this a little bit more globally, because as divorce lawyers, we deal with our counsel in our case. So, understanding what our counsel do in a case when you're representing one of the parties is really important. Always keep in mind that, as Jennifer just said, their job is to represent the child's voice, to give that child their voice to the court. So when they're doing their job, understand they're doing their job, and understand that they're to advocate for their client. That is their job. We're the zealous advocates. That's the oath that we take when we get sworn in as lawyers. So understand what that's going to do, and if it turns out that you're representing the child, representing the parent who is sort of on the side of the child, they're aligned with their interests, work with that lawyer. I've in the cases I've tried as ARC counsel, your partner, sat down and talked about how we're going to try this case. What's the best evidence to put forward to get what our two clients want? That's what we do as trial lawyers, and it's acceptable. That's the way it is, and don't be afraid to talk to them about it. Also, if you're representing the parents before you get to that stage and you don't know where things might end up, help our counsel understand the child through the parents. The parents can give so much information about the context of what's going on, the context of where that child is developmentally and so forth, and to get that child's voice more appropriately and accurately heard by the court, sometimes it's really important for the parents to help our counsel understand who their child client is. And then finally, keep in mind that overwhelmingly the cases with our counsel settle. 96% of cases, I think, settle anyway. That's the statistic I've heard. So what I always do in my practice, I try to front load the information part. Give them as much information on the other side. Information up the wazoo. I don't care about informal, formal, whatever. Because a settlement requires two things. One, enough information to make a reasonable decision. And two, reasonable clients. If I can front load the first part, we can get to the second part. And don't forget that our counsel can help you do that. The information can be what the child wants, and then our counsel can help broker a settlement and use them, because good art counsel helps settle cases.
I guess my takeaway would be to just be sure to realize that GAL is there to look out for the best interest of the child, not to take a side. And I'm not looking at mom's best interest or dad's best interest, but just the child's best interest. And in doing that, I try very hard to make sure I don't make it worse for this child. So I think as GALs, that's what we all need to do, is really try to get through this and make the child walk away from this without feeling worse than when you went in to first interview the child. The child's voice for me is not just what they say, but how they act, what I observe, what they're doing in school. All of that stuff that I put in the report, in my opinion, is also the child's voice. And I think we just all have to be careful to make sure that we're really gentle with the children and make sure that we're not hurting them and not making things worse for them.
That's the big thing. It's all about the kids.
Right.
That's
And I
what
think
I'm talking about.
sometimes when my report comes in and it looks like it favors one side or the other, suddenly I'm on one person's side and that's how the trial is going to go, and I'm really not. I'm really on the child's side, and I'm saying what I think is best for the child.
Important distinction to make, for sure. Any questions, comments from anybody? No? Great, Chris, finished on time. Thank you very much.
Yeah, thank you.
Thanks.
Thank you both.